Trial resumed. Jury not present.
The court said, "Good morning. Would you make your appearances, please?"
Ms. Murray said, "Juliana Murray and Justin Horton for the United States." And will be joined by our colleagues Ryan Finkel and Micah Fergenson.
Mr. Skirick said, "Good morning, Your Honor." Scott Skirick. Sabrina Schroff and Matthew Barkin together at counsel's table with Mr. Gua, and will be joined shortly by Mr. Kamraju.
The court said, "Please be seated. I'm told that there is a delay on the New Haven line and that alternate 3 is not here yet, so I would like to wait for him. Is there anything you'd like to raise?"
Ms. Murray said, "Your Honor, just with respect to anticipated timing the parties have discussed. We estimate that there's maybe 40 minutes left in the court's instructions up until the end of Section 5. We would request maybe a 5-minute break after that point to permit the government to set up for closing arguments. Move the podium, get the text set up. We anticipate that the government's summation will be around 3 hours. It might be a little bit more than that. We understand there will be a comfort break for the jurors at some point in the middle of that. We would just ask, we'll be cognizant of the approximately 11:30 timing depending when we start. But we ask the court's permission to make sure that it's in a kind of reasonable breaking point. Like at the end of a section or the end of a slide or something like that."
The court said, "Sure."
Ms. Murray said, "With respect to lunch timing working forward from when the government's summation begins. And building in the 10 or 15-minute break that there would be. We anticipate probably 1:15 or 1:30 for the lunch break because that would be, I guess, between the government's and the defense summations. We understand Mr. Kamraju's summation is probably around 3 hours, maybe a bit less than that. And then we would ask for a brief break, 5 minutes or so, for the jurors to stretch their legs. And then the government's rebuttal would probably be around an hour. Maybe a little bit less depending on the defense closing. Doing the math, it makes for a pretty long day. We've discussed with defense counsel, and we just wanted to let the court know, the timing is fluid. It seems quite likely that we wouldn't be in a position to be able to complete all 3 summations today. I'm not sure if the court wants to inquire whether the jurors can stay late. The parties are open to that. Although I would note that it might be a situation even if they can where we reevaluate later in the day. We wouldn't want to be in a position where the summations run over. And then the rebuttal is truncated just due to scheduling."
Mr. Skirick said, "Thank you, Your Honor. We're broadly in agreement with what Ms. Murray outlined as the process for today. We would just ask, particularly in light of alternate number 3's delay in getting to court today, if we may inquire with the jury as to their ability to stay a bit late today in order to build some time back in. Perhaps a half hour or so to 5:30 in the interest of getting in as much today as possible and in hopes that we can finish all the summations today so that the jury can begin deliberations tomorrow."
The court said, "So I contemplate giving them a half-hour break for lunch. Is that what you were thinking?"
Mr. Skirick said, "Yes, Your Honor."
Ms. Murray said, "Yes, Your Honor."
The court said, "It sounds very ambitious."
Mr. Skirick said, "But worthwhile, Your Honor."
Ms. Murray said, "I tend to agree."
The court said, "Based on my own experience, to me it does not seem that we will necessarily be able to finish the defense summation, so I think we need to play it by ear, and I would like you to prompt me concerning the breaks."
Ms. Murray said, "Yes, Your Honor. We're happy to do that and we really appreciate that. We've spoken with AUSA Finkel. And we're aware of how the timing would work. And for the morning break that would be in the middle of his summation. We'll make sure it's at an appropriate stopping point. We'll give as much kind of notice to your clerks so they can advise you so you'll be aware of what the timing is during the summation."
Mr. Skirick said, "Likewise we'll do the same during defense summation."
The court said, "I can inquire as to whether they can stay another half hour. I know that juries tend not to like that."
Mr. Skirick said, "Your Honor. One sort of potential alternative just to suggest it to the court for the court's consideration is in light of the delay in alternate number 3 coming to court is to tell the jury that in lieu of finishing the charge this morning that perhaps we go into summations this morning and finish the charge at the end of summations when everyone is here perhaps tomorrow morning."
The court said, "So I don't think that is a good idea. Especially because what is left is the racketeering charge, which is not a crystal clear concept. And I think it helps them to first hear about the law as it is so that they can better assimilate the arguments. Alrighty.
Mr. Skirik said, we just have two housekeeping matters from the defense. One comes out of the defense's Stip 2, which was entered into evidence yesterday. The court may recall that I referred during defense Stip 2 to a subset of documents. A subset of defense exhibits that would be moved in. We have agreement with the government, I believe, on what that subset is. I'm happy to read it into the record now to have Your Honor move it informally if that's okay. It's a series of numbers and letters as usual.
The court said, go ahead.
Mr. Skirik said, defense moves in DX40017.1 through DX40017.18, DX40019.1 through DX40019.4, DX40021.1 through DX40021.2, DX40024.1 through DX40021.9, DX40037.1 through DX40037.4, DX40052.1 through DX40052.7, DX40053.1 through DX40053.4. In addition, DX40017T, DX40019T, DX40021T, DX40024T, DX40037T, DX40052T, and finally DX40053T. And we move those into evidence.
The court said, they are admitted. Defendants exhibits DX40017.1 through DX40017.18, DX40019.1 through DX40019.4, DX40021.1 through DX40021.2, DX40024.1 through DX40021.9, DX40037.1 through DX40037.4, DX40052.1 through DX40052.7, DX40053.1 through DX40053.4. DX40017T, DX40019T, DX40021T, DX40024T, DX40037T, DX40052T, DC40053T received in evidence.
Mr. Skirik said, one final matter to pick up on, a loose end from yesterday. The court may recall we had a discussion at yesterday's 9 o'clock about whether it's permissible for the defense to argue in summation certain inferences from the record evidence, including in particular the testimony of Mr. He, who has been manipulated by the CCP in China. I would just like to address that briefly, Your Honor. Now that we had a chance to review the record and appreciate the court's indulgence on that score. Just as a background matter, the law, Your Honor, as we understand it based on Second Circuit's precedent, is that counsel have broad latitude in inferences they may reasonably suggest to the jury during summation. That is United States v. Edwards. 342 F.3d 168, 2 DCIR 2003. And counsel are free to make arguments which may reasonably be inferred from the evidence presented. That's United States v. Roland Zapata, 916 F.2d 795, 2 DCIR 1990. Your Honor, as the court well knows through the Fox Hunt Stip, which is the defense Stip 1, it is aptly in evidence that a principal goal of the Fox Hunt initiative was to discredit Mr. Gui using multiple means, and that the MSS tasked a specially formed group to that end. The court heard testimony from the defense expert Paul Doran, who testified as to, among other things, the CCP's tactics in manipulating its citizens by accusing them of false or gradually exaggerated crimes. The court also heard testimony from Mr. He, which I referred to before. He testified that what the Chinese police did to him, not only detaining him in China and forcing him to sign false complaints to the U.S. authorities, including the FBI and DOJ, but also abusing the U.S. judicial system itself by causing false civil complaints and lawsuits to be filed on Mr. He's behalf here in the United States. Next, the court also heard testimony from the government's witness Ms. Yili, also known as Mulan. Ms. Li testified that her parents in China were contacted by the CCP and told to tell her to stop all of her war-related activities because they threatened national security. In addition, as part of the defense's good faith basis for being able to argue the inferences that we request. Your Honor, there was 3,500 material produced by the government relating to Mulan, relating to Yai Li. After Ms. Li's testimony was over in this case, in which Ms. Li reported that she heard reports similar to the ones that Mr. He testified to, and that Chinese police approach people, and this is a quote from the 3,500. She heard similar reports where Chinese police approach people and instruct them to report to the FBI. This is all real, true, no people in mainland China in jail.
The court said, so if you could just identify specifically where you're getting that from?
Mr. Skirik said, yes, Your Honor. This is the 3,500 produced by the government, I believe, on July 1st of this year. And again. That's further to Ms. Li's record testimony where she testified that her parents in China were contacted by the police and the request was passed along to them to tell her to stop her activities. There's also, I believe, it's aptly in evidence that there are numerous of the government's witnesses who still have relatives in China who are of course susceptible to the same coercion by the CCP as long as they're in mainland China. And for those among other reasons, we think it's entirely proper based on Second Circuit precedent for the defense to be able to argue that what happened to Mr. He, that it is plausible and possible that has happened to other complainants, including the government's witnesses, victim witnesses, but not limited just to the victim witnesses, Your Honor. Just for the record, the cite to the 3,500 that I just referred to is 3613-071, Ms. Yai Li's 3,500 produced July 1st.
Mr. Horton said, Your Honor ruled on this yesterday morning. Mr. Skirik said that they would like to argue that it's a fact in evidence that the CCP planned to coerce people in China into making false complaints. So the defense ought to be able to argue to the jury in closing that that is something that has likely happened with respect to others besides Mr. He. And Your Honor ruled, and I'm quoting Your Honor, this is a very hard no. No. You cannot make that argument. That was correct. We cited a number of Second Circuit cases for Your Honor yesterday that confirm that the trial judge has broad discretion to limit the defense summation for the purpose of excluding arguments that are not tethered to facts in evidence. This is a particularly prejudicial argument. Mr. He's testimony, reviewed it quite closely, focused entirely on his personal experience. And indeed that was what the court said was permissible testimony from the defense witnesses. Limited to their investing experience. He didn't testify about anybody else's experience. It wouldn't have been permissible for him to testify about anybody else's experience. It wouldn't have been permissible under Rule 608 for them to try to impeach another victim witness through Mr. He. And they didn't do that. This talk about victim witnesses having parents in China. They would have made a choice to cross-examine victims before the jury and suggest to the jury that their testimony was false or not trustworthy because their parents live in China. They chose not to do that. And what they're trying to do, and what Your Honor ruled on, is to take a single victim's, a single investor's testimony limited to his own experience, and I can go through specific sites in the transcript to show how limited it was, and extrapolate from that to really unfortunate innuendo against the victim witnesses in the case. And Your Honor said it was a very hard no, and that was absolutely correct.
Mr. Skirik said, Your Honor, a few things. One is that the court may recall after you'd said that on the record yesterday. You did in fact give the defense the opportunity to come back and present what I said would be a fuller record on the issue. So that's what we're doing here, so respectfully we do not believe that the court ruled on this issue. You left it open in order for us to present to you what we just presented to you. That's point one.
The court said, Mr. Skirik, when Ms. Li was testifying, did you raise this question about what she may have heard about others?
Mr. Skirik said, yes.
The court said, I'm asking whether you cross-examined on the issue?
Mr. Skirik said, we did cross-examine and elicited testimony, Your Honor, about her parents having been contacted by the CCP police in China.
The court said, no, I'm talking about others, people that are not related to her?
Mr. Skirik said, yeah, Your Honor. I'm not sure that we would have been able to do that. It would have elicited hearsay. which I'm sure that the court would not have permitted. But I think, Your Honor, if I may, the point is not.
The court said, so what you're saying is that her knowledge of the others is not in evidence. Isn't that what you're saying?
Mr. Skirik said, Your Honor, what we're saying is, we're not bound as I understand it to have to show that each of the individual witnesses that the government called are aware of others being manipulated the way that they were.
The court said, but you have to have some evidence in the record from which to draw a reasonable inference. So far the evidence has pertained only to testifying individuals and the evidence is now closed.
Mr. Skirik said, if I may point out to the court, we have Mr. E whose testimony we all knows goes directly to this issue. Right.
The court said, his personal experience.
Mr. Skirik said, correct, his personal experience.
The court said right.
Mr. Skirik said, in addition, we have Ms. Lee's personal experience, Mulan's personal experience. We also have Mr. Doran's expert testimony about the methods by which the Chinese government and CCP coerce its own citizens in China into doing things. And we also have testimony from numerous victim witnesses who say that they have family who lives in China. And I would submit to the court that when you put all of that together, there is enough of a factual basis from which the defense ought to be able to argue there is a reasonable inference that this could and may have happened with respect to others. There's no reason to believe that the personal experience of Mulan and the personal experience of Mr. He were limited to just them in light of Mr. Doran's testimony about the way that the Chinese government goes about manipulating its citizens. That is, I think, more than enough basis to draw the inference that the defense request.
The court said, is there anything further from the government?
Mr. Horton said, no. Your Honor's ruling yesterday was correct.
The court said, all righty. So,
Mr. Skirik said, one more point.
The court said, I don't agree that you can generalize and speculate based on the testimony in this case, and so I adhere to my decision. Anything further?
Mr. Horton said, not from the government. Thank you, Your Honor. Judge.
Mr. Skirik said, not from the defense. Thank you.
The court said, I'm just waiting from an update as to the alternate as to his anticipated arrival time. I will let you know.
Ms. Murray said, thank you, Your Honor.
Recess. Continued on next page. Jury not present.
The court said, all the jurors are present. You would have them brought in, please.
The law clerk said, jury entering.
Jury present.
The court said, please be seated. Good morning, jurors. Please turn to page 50 of the jury charge. I am now going to continue reading the instructions. Finally, I will turn to count 1, which charges the defendant with conspiring to violate the federal racketeering statute, Section 1962C, of Title 18 of the United States Code. The statute is commonly referred to as RICO, which stands for the Racketeer Influenced and Corrupt Organizations Act. The instructions for this charge have several steps, and I will walk through them one by one. Let me first note that the word racketeering may have implications in ordinary English. Do not infer anything from it. The word, as used in this statute, is a purely technical term that is defined specifically for this statute. The RICO statute makes it a crime for any person employed by or associated with any enterprise engaged in, or the activities of which affect interstate or foreign commerce, to conduct or participate, directly or indirectly, in the conduct of such enterprises' affairs through a pattern of racketeering activity. Count 1 of the indictment charges the defendant with participating in a racketeering conspiracy from in or about 2018 through in or about March 2023. In order to meet its burden of proving that the defendant is guilty of the racketeering conspiracy charged in Count 1, the government must establish beyond a reasonable doubt each of the following elements. First, that at or about the time charged in Count 1, the conspiracy charged in the indictment existed, that is, that an agreement or understanding between two or more persons existed to conduct or participate in the conduct of a racketeering enterprise. Second, that the racketeering enterprise or its activities would have affected, or in fact affected, interstate or foreign commerce. Third, that the defendant knowingly and intentionally joined the conspiracy. And fourth, that the defendant knowingly and intentionally agreed with at least one other person that either he or a co-conspirator would participate, either directly or indirectly, in the conduct of the affairs of the enterprise through a pattern of racketeering activity. as described in the indictment, that is, that either the defendant or a co-conspirator would commit at least 2 acts of racketeering activity. The first element the government must prove beyond a reasonable doubt is the existence of the conspiracy alleged in Count 1 of the indictment, that is, the agreement to conduct or participate in the conduct of a racketeering enterprise. Before I define these technical terms, I remind you that it is not necessary that a conspiracy actually succeed in its purpose for you to conclude that it existed. Because the agreement to commit a racketeering offense is the essence of Count 1, the government need only prove that if the conspiracy achieved its objective as contemplated, the enterprise would be established and that its members would participate in conducting the affairs of the enterprise through a pattern of racketeering activity. Of course, proof that the objective of the conspiracy was accomplished, if you find it was, may be the most persuasive evidence of the existence of the conspiracy. The object of a conspiracy is the illegal purpose the conspirators agree or hope to achieve. The object of the conspiracy charged in Count 1 is to violate the RICO statute, in other words, to conduct or participate in the conduct of the affairs of an enterprise through a pattern of racketeering activity. What is an enterprise? Under the racketeering statute, an enterprise includes any legal entity such as a partnership, corporation or association, or a group of individuals who are associated in fact, although not a legal entity. The enterprise does not need to have a particular name, or for that matter, have any name at all. Nor need it be registered or licensed as an enterprise. It does not have to be a commonly recognized legal entity, such as a corporation, a trade union, a partnership, or the like. But an enterprise could be a legal entity or a group of legal entities. An enterprise may be a group of people informally associated together for a common purpose of engaging in a course of conduct. This group may be organized for a legitimate and lawful purpose, or it may be organized for an unlawful purpose. In addition to having a common purpose, this group of people must have a core of personnel who function as a continuing unit. Furthermore, the enterprise would continue to exist, or did continue to exist, in substantially similar form through the period charged, in this case from 2018 through March 2023. This does not mean that the membership must remain exactly identical, but the enterprise must have a recognizable core that continues through a substantial period during the time frame charged in the indictment. Count 1 of the indictment defines the charged conspiracy as an agreement to participate in the conduct of an organization, referred to by the government as the G enterprise. The term G enterprise is simply a form of reference used by the government in the indictment to describe the group of businesses and individuals who participated in the alleged racketeering conspiracy. The government is not required to prove each and every allegation about the G enterprise. If you find that there was an agreement to conduct or participate in the conduct of a group of people characterized by 1. A common purpose, 2. An ongoing formal or informal organization, and 3. Personnel who function as a continuing unit, then you may find that the first element of a racketeering conspiracy has been satisfied. The second element that the government must prove beyond a reasonable doubt is that the enterprise itself, or the racketeering activities of those associated with it, would have some effect on interstate or foreign commerce, or in fact had such an effect. This effect on interstate commerce could have occurred in any way, and it need only have been minimal. Interstate commerce includes the movement of goods, services, money, and individuals between states. It is not necessary for the government to prove that any particular acts affected interstate commerce or even that acts that the defendant personally committed affected interstate commerce. It need only prove that some act or acts of the enterprise, even perfectly legal acts of the enterprise, had such an effect on interstate commerce. It is not necessary for you to find that the defendant knew the enterprise was engaged in interstate commerce. All that is necessary is that you find beyond a reasonable doubt that the activities of the enterprise would affect, or did affect, interstate or foreign commerce in some minimal way. The third element the government must prove beyond a reasonable doubt is that, at some point during the time period charged in the indictment, 2018 through March 2023, the defendant was a member of the charged conspiracy. I previously instructed you about participation in a conspiracy, and you should follow those general instructions here. See pages 31 to 35. You must determine not only whether the defendant participated in the conspiracy, but also whether he did so intentionally and knowingly, that is, did he participate in the conspiracy with knowledge of its unlawful purpose, and with the specific intention of furthering the objective of that conspiracy? As I've previously instructed you, a conspiracy is an agreement or partnership by two or more persons to violate the law. The object of a conspiracy is the illegal purpose the conspirators agree or hope to achieve. The object of the conspiracy charged in Count 1 is to violate the RICO statute, in other words, to conduct or participate in the conduct of the affairs of an enterprise through a pattern of racketeering activity. Even if a defendant did not personally participate in the operation or management of the enterprise, he may be convicted of a RICO conspiracy offense when the evidence establishes that the defendant knowingly agreed to facilitate a scheme which, if completed, would constitute a RICO substantive violation. Similarly, the government need not prove that the defendant agreed with every other member of the enterprise, knew all of the other members of the enterprise, or had full knowledge of all of the details of the enterprise. However, in proving this element, the government must prove that the defendant was connected to the enterprise in some meaningful way, and that the defendant knew the general nature of the enterprise and knew that the enterprise existed beyond his individual role. When considering if the defendant joined the conspiracy, you may consider evidence, if any, that the defendant agreed that a conspirator would intentionally perform acts, functions or duties which are necessary to, or helpful in the operation of the enterprise, or that a conspirator had some part in directing the enterprise's affairs. However, the government need not prove that the defendant would exercise significant control over or within the enterprise, or that he had a formal position in the enterprise, or that he had primary responsibility for the enterprise's affairs. An enterprise is operated not just by upper management, but also by lower-rung participants in the enterprise who are under the direction of upper management carry out upper management's orders. I want to caution you, however, that the defendant's mere presence at the scene of a crime does not, by itself, make him a member of the conspiracy. Similarly, mere association with one or more members of the conspiracy does not automatically make the defendant a member. A person may know or be friendly with a criminal without being a criminal himself. Mere similarity of conduct or the fact that they may have assembled together and discussed common aims and interests does not necessarily establish membership in the conspiracy. What is necessary is that the defendant participated with knowledge of the unlawful objective of the conspiracy and with intent to aid in the accomplishment of that objective. Ultimately, the question is this: has the government proven beyond a reasonable doubt that the defendant joined the conspiracy and knowingly and intentionally participated in it with the awareness of its basic purpose and as something he wished to bring about? The fourth element that the government must prove beyond a reasonable doubt is that the defendant knowingly conspired or agreed to participate in the conduct of the affairs of the enterprise through a pattern of racketeering activity. The focus of this element is on the defendant's agreement to participate in the objective of the enterprise to engage in a pattern of racketeering activity, and not on the defendant's agreement to commit the individual criminal acts. The government must prove that the defendant agreed to participate in the enterprise with the intent that he or another member or members of the conspiracy would commit two or more racketeering acts, which I will describe. The government is not required to prove that the defendant agreed to commit two racketeering acts himself, or that he actually committed two such acts. As I told you, it is not necessary that a conspiracy actually succeed in its purpose for you to conclude that it existed. Because the agreement to commit a racketeering offense is the essence of Count 1, the government need only prove that if the conspiracy achieved its objective as contemplated, the enterprise would be established, that its members would participate in conducting the affairs of the enterprise through a pattern of racketeering activity, and that those activities would affect interstate or foreign commerce. A pattern of racketeering activity requires at least two acts of racketeering, the last of which occurred within 10 years after the commission of a prior act of racketeering. These acts are referred to as predicate acts for the RICO conspiracy charge. To establish an agreement that the enterprise would engage in a pattern of racketeering activity, as alleged in Count 1 of the indictment, the government must prove three things beyond a reasonable doubt. First, that the defendant agreed that a conspirator, which could be the defendant himself, would intentionally commit or cause or aid and abet the commission of two or more of the racketeering acts of the types alleged in Count 1 of the indictment. You must be unanimous as to which particular types of racketeering crimes, if any, the defendant agreed would be committed. For example, wire fraud, securities fraud, bank fraud, money laundering, or any combination thereof. Second, that the racketeering acts have a nexus to the enterprise and the racketeering acts are related to one another. A racketeering act has a nexus to the enterprise if it has a meaningful connection to the enterprise. To be related, the racketeering acts must have the same or similar purposes, results, participants, victims, or methods of commission, or be otherwise interrelated by distinguishing characteristics, and not be merely isolated events. Two racketeering acts may be related, even though they are dissimilar or not directly related to each other, provided that the racketeering acts are related to the same enterprise. For example, for both nexus and relatedness purposes, the requisite relationship between the RICO enterprise and a predicate racketeering act may be established by evidence that a person was enabled to commit the racketeering act solely by virtue of his position in the enterprise or involvement in or control over its affairs, or by evidence that a person's position in the enterprise facilitated his commission of the racketeering act, or by evidence that the racketeering act benefited the enterprise, or by evidence that the racketeering act was authorized by the enterprise, or by evidence that the racketeering act promoted or furthered the purposes of the enterprise. Third, to establish a pattern of racketeering activity, the government must prove either 1, that the racketeering acts themselves would have extended over a substantial period of time, or 2, that they posed or would pose a threat of continued criminal activity. A threat of continued criminal activity need not be proven by any mathematical formula, or by any particular method of proof. Rather, it may be proven in a variety of ways. For example, the threat of continued unlawful activity may be established when the evidence shows that the racketeering acts are part of an enterprise that exists solely for criminal purposes, or when the racketeering acts are shown to be the regular way of conducting the affairs of the enterprise, even where the enterprise also operates for legitimate, non-criminal purposes. Moreover, in determining whether the government has proven the threat of continued unlawful activity, you are not limited to consideration of the specific racketeering acts that the defendant and his co-conspirators are alleged to have committed. Rather, in addition to considering such acts, you also may consider the nature of the enterprise and other unlawful activities of the enterprise and its members viewed in their entirety, including both charged and uncharged unlawful activities. For a conviction under Count 1, the government must prove that the defendant intended to further an endeavor which, if completed, would have satisfied all the elements of a substantive racketeering offense. The government is not required to prove that the defendant personally committed or agreed to commit any act of racketeering, nor is it required to prove that any acts of racketeering actually occurred. Rather, the government must prove that the defendant agreed to participate in the enterprise with the knowledge and intent that at least one member of the racketeering conspiracy, which could be the defendant himself, would commit at least 2 racketeering acts in the conduct of the affairs of the enterprise, and that those acts would constitute a pattern of racketeering activity as defined above. Enterprise v. Pattern of racketeering activity. Let me make clear that an enterprise is not the same thing as the pattern of racketeering activity. To convict, the government must prove that if the conspiracy achieved its objective there would be an enterprise, and that the enterprise's affairs would be conducted through a pattern of racketeering activity. The enterprise in this case, which the government refers to as the G enterprise, is alleged to be a group of individuals and businesses who associated together for a common purpose of engaging in a course of conduct. A pattern of racketeering activity, on the other hand, is a series of criminal acts. The existence of the enterprise is proven by evidence of an ongoing organization, formal or informal, with a common purpose, and by evidence that various core personnel of the group functioned as a continuing unit. The pattern of racketeering activity, on the other hand, is proven by evidence of a minimum of 2 acts of racketeering that the participants in the enterprise agreed would be committed. The proof used to establish those separate elements may be the same or overlapping. For example, if you find that an ongoing enterprise existed, the existence of this enterprise may help establish that the separate racketeering acts were part of a pattern of continuing criminal activity. Nevertheless, you should bear in mind that proof of an enterprise does not necessarily establish proof of a pattern of racketeering activity, and vice versa. Finally, although you need not decide whether the defendant agreed to the commission of any particular racketeering act in order to convict him of the RICO conspiracy offense, you must be unanimous as to which type or types of predicate racketeering crimes the defendant agreed would be committed. For example, wire fraud, securities fraud, bank fraud, money laundering, or any combination thereof. The indictment alleges that the following categories of criminal violations were committed or were intended to be committed as part of the racketeering conspiracy charged in Count 1. 1 Acts involving wire fraud, in violation of federal law. 2 Acts involving bank fraud, in violation of federal. 3 Acts involving the laundering of monetary instruments, also known as money laundering, in violation of federal law. 4 Acts involving engaging in monetary transactions in property derived from specified unlawful activity, in violation of federal law. And 5 Acts involving securities fraud, in violation of federal law. The government does not need to prove that the defendant agreed that all of these types of racketeering crimes would be committed. As I explained, the government must prove that the defendant agreed that at least 2 racketeering acts would be committed. Those acts may be within the same category of racketeering activity, such as 2 acts of wire fraud, or those acts may be within different categories of racketeering activity, such as 1 act of wire fraud and 1 act of money laundering. I previously instructed you on violations of the wire fraud statute, in connection with counts 5, 7, 9, and 11, see pages 16 to 21. You should use those instructions in assessing whether acts involving wire fraud, in violation of federal law, were committed or intended to be committed. I previously instructed you on violations of the bank fraud statute, in connection with the bank fraud object of Count 2's conspiracy to commit wire fraud and bank fraud, see pages 37 to 40. You should use those instructions in assessing whether acts involving bank fraud, in violation of federal law, were committed or intended to be committed. I previously instructed you on violations of the money laundering statute, in connection with the objects of the money laundering conspiracy alleged in Count 3, see pages 40 to 47. You should use those instructions in assessing whether acts involving the laundering of monetary instruments, also known as money laundering, in violation of federal law were committed or intended to be committed. I previously instructed you on violations of engaging in monetary transactions in property derived from specified unlawful activity, in connection with Count 12, see pages 27 to 29. You should use those instructions in assessing whether acts involving engaging in monetary transactions in property derived from specified unlawful activity were committed or intended to be committed. And I also previously instructed you on violations of the securities fraud statute, in connection with Counts 6, 8, and 10, see pages 22 to 27. You should use those instructions in assessing whether acts involving securities fraud, in violation of federal law, were committed or intended to be committed. With respect to each count in the indictment, the government, in addition to proving the essential elements of that charge, must also prove that at least 1 act in furtherance of the charge occurred in the Southern District of New York. This is called establishing venue. The Southern District of New York includes all of Manhattan and the Bronx, as well as Westchester, Rockland, Putnam, Dutchess, Orange, and Sullivan counties. The government does not have to prove that a completed crime was committed within the Southern District of New York, or that the defendant was ever in the Southern District of New York. It is sufficient to satisfy the venue requirement if any act in furtherance of the crime charged occurred in this district. The act itself need not be a criminal act, and the act need not have been taken by the defendant, so long as the act was part of the crime that you find the defendant committed. The defendant did not testify in this case. Under our Constitution, a defendant has no obligation to testify or to present any evidence, because it is the government's burden to prove a defendant guilty beyond a reasonable doubt. That burden remains with the government throughout the entire trial, and never shifts to a defendant. A defendant is never required to prove that he is innocent. You may not attach any significance to the fact that the defendant did not testify. No adverse inference against him may be drawn by you because he did not take the witness stand. You may not hold this against him or consider it in any way in your deliberations in the jury room. You heard the testimony of some witnesses who are law enforcement officers and employees of the FBI. The fact that a witness works for the government or in law enforcement does not mean that the witness's testimony is, by virtue of the witness's position, deserving of more or less consideration, or greater or lesser weight, than that of any other witness. The testimony of such a witness should not be regarded as more or less truthful or accurate than that of any other witness simply based on the witness's employment. It is your decision, after reviewing all of the evidence, whether to accept the testimony of the law enforcement witness and to give that testimony whatever weight, if any, you find it deserves. You heard testimony from what we call an expert witness. An expert is a witness who, by education or experience, has acquired learning or experience in a specialized area of knowledge. Expert witnesses are permitted to express their opinions as to relevant matters in which they have special knowledge, skill, experience, and training, and to give their reasons for their opinions. Expert testimony is presented to you on the theory that someone who is experienced in the field can assist you in understanding the evidence or in reaching an independent decision on the facts.
Continued on next page.
The court said, your role in judging credibility applies to experts, as well as other witnesses. In weighing this opinion testimony, you may consider a witness's qualifications, his or her opinions, the reasons for testifying, as well as all of the other considerations that ordinarily apply when you are deciding whether or not to believe a witness's testimony. You may give the opinion testimony whatever weight, if any, you find it deserves in light of all the evidence in this case. You should not, however, accept opinion testimony merely because I allowed the witness to testify concerning his or her opinion, nor should you substitute it for your own reason, judgment, and common sense. The determination of the facts in this case rests solely with you. As with the testimony of any other witness, you may decide to accept all, some, or none of the testimony of any expert witness. If you should decide that the opinion of an expert was not based on sufficient education or experience or on sufficient data, or if you should conclude that the trustworthiness or credibility of an expert is questionable for any reason, or if the opinion of the expert was outweighed in your judgment by other evidence in the case, then you may disregard the opinion of the expert entirely or in part. On the other hand, if you find the opinion of an expert is based on sufficient data, education, and experience, and the other evidence does not give you reason to doubt his or her conclusions, you would be justified in placing reliance on his or her testimony. You heard testimony from witnesses who entered into non-prosecution agreements with the government arising out of facts that are at issue in this case. You are instructed that you are to draw no conclusions or inferences of any kind about the guilt of the defendant from the fact that a witness entered into such an agreement, even involving similar conduct. The decision of that witness to enter into that agreement is a personal decision. Likewise, the government's decision to enter into the agreement is a lawful exercise of its discretion. Fourth, you may consider whether the fact that the witness entered into the agreement affects the credibility of their testimony. You have heard evidence that the defendant and certain entities were represented by attorneys. A lawyer's involvement with an individual or entity does not make that individual or entity's actions legal. You heard evidence that witnesses may have discussed the facts of this case with the defense lawyers or with government lawyers before they appeared in court. Although you may consider that fact when you are evaluating a witness's credibility, there is nothing either unusual or inherently improper about a witness meeting with the defense lawyers or the government lawyers before testifying so that the witness can be aware of the subjects he or she will be questioned about, focus on those subjects, and have the opportunity to review relevant exhibits before being questioned about them. Such consultation helps conserve your time and the court's time. In fact, it would be unusual for a lawyer to call a witness without such consultation. The weight you give to the fact or the nature of the witness's preparation for his or her testimony, and what inferences you draw from such preparation are within your discretion. There are several people whose names you heard during the course of the trial, but who did not appear here to testify. I instruct you that each party had an equal opportunity, or lack of opportunity, to call any of these witnesses. Therefore, you should not draw any inference or reach any conclusions as to what they would have said if they had been called to testify. Their absence should not affect your judgment. You should, however, remember my instruction that the law does not impose on a defendant in a criminal case the burden or duty of calling any witness or producing any evidence. The burden remains with the government to prove the defendant guilty beyond a reasonable doubt. In this case, you heard evidence in the form of stipulations of fact. A stipulation of fact is information the parties agree to present to the jury as evidence without calling a witness to testify. The parties agree that the facts contained in the stipulations are true. You must accept those facts as true. Some of the exhibits were submitted in the form of charts and summaries. For the charts and summaries that were admitted into evidence, you should consider them as you would any other evidence. You heard testimony about evidence seized in connection with certain searches conducted by law enforcement officers. Evidence obtained from these searches may be properly considered by you. Such searches were lawful law enforcement actions. Whether you approve or disapprove of how the evidence was obtained should not enter into your deliberations because I instruct you that the use of the evidence is lawful. You must, therefore, regardless of your personal opinions, give this evidence full consideration, along with all the other evidence in the case in determining whether the government has proved the defendant's guilt beyond a reasonable doubt. You will note that the indictment alleges that the charged crimes occurred in or about 2018 to March 2023. It does not matter if the evidence you heard at trial indicates that a particular act occurred on a different date. The law requires only a substantial similarity between the date alleged in the indictment and the date established by the evidence. You heard reference in the arguments, you will hear reference in the arguments of counsel to the fact that certain investigative techniques were, or were not used by law enforcement authorities. You may consider these facts in deciding whether the government has met its burden of proof, because you should look to all of the evidence or lack of evidence in deciding whether the defendant is guilty. However, there is no legal requirement that law enforcement agents investigate crimes in a particular way, or that the government prove its case through any particular means. The government and its techniques are not on trial. Although you are to carefully consider the evidence presented, you need not speculate as to why law enforcement used the techniques they did, or why they did not use other techniques. Your concern is to determine whether or not, based on the evidence or lack of evidence, the guilt of the defendant has been proven beyond a reasonable doubt. The government has introduced evidence in the form of audio and video recordings. Whether you approve or disapprove of the recording of these conversations may not enter into your deliberations. I instruct you that these recordings were made in a lawful manner, and that no one's rights were violated, and that the government's use of this evidence is lawful, and it was properly admitted into evidence at this trial. You must, therefore, regardless of any personal opinions, give this evidence consideration, along with all the other evidence in the case, in determining whether the government has proven the defendant's guilt beyond a reasonable doubt. If you wish to hear any of the recordings again, they will be made available to you during your deliberations. During the trial, you were given transcripts of recordings which were admitted into evidence. These transcripts were translations of foreign language recordings in Mandarin. You were also shown translations of foreign language documents. Although some of you may know Mandarin, it is important that all jurors consider the same evidence. Therefore, you must accept the English translations that are in evidence and disregard any different meaning. Among the exhibits received in evidence are some exhibits that are redacted. Redacted means that part of the document or recording was taken out. You are to concern yourself only with the part of the item that has been admitted into evidence. You should not speculate as to any reason why the other part of it has been redacted. Some of the people who may have been involved in the events leading to this trial are not on trial. This does not matter. There is no requirement that all people jointly engaged in criminal activity be charged and prosecuted or tried together in the same proceeding. You may not draw any inference, favorable or unfavorable, toward the government or the defendant from the fact that certain persons other than the defendant were not named as defendants in the indictment. Nor may you speculate as to the reasons why other persons are not on trial. Those matters are wholly outside your concern, and have no bearing on your function as jurors. Your verdict must be based solely upon the evidence developed at trial or the lack of evidence. In reaching your decision as to whether the government sustained its burden of proof, it would be improper for you to consider any personal feelings, positive or negative, you may have about the defendant's race, religion, national origin, sex or age. The defendant and the government are both entitled to a trial free from prejudice. And our judicial system cannot work unless you reach your verdict through a fair and impartial consideration of the evidence. I'm also going to ask you and advise you to not decide the case based on implicit biases. Everyone, including me, has feelings or assumptions or perceptions or fears or even stereotypes, and they're referred to as implicit biases, and you might not even be aware of them. These hidden thoughts can impact what we see and hear, how we remember what we see and hear, and how we make important decisions. Because you are making important decisions in this case, I strongly encourage you to evaluate the evidence carefully and to resist jumping to any conclusions based on personal likes or dislikes, generalizations, gut feelings, prejudices, sympathies, stereotypes, or biases. Members of the jury. Next, we turn to another stage of the trial, and so you may put down your instructions. But before we turn to the summations, we're going to take a 5-minute break. Remember, do not discuss the case amongst yourselves or with anyone else. Don't permit anyone to discuss the case in your presence. Don't read, watch, or listen to anything from any source concerning any topic that touches upon this trial.
Jury not present.
The court said, you may be seated. I understand the government is going to take time now to set up.
Mr. Finkel said, yes, Your Honor.
Recess.
The court said, please have the jurors brought in.
Jury present.
The court said, please be seated. Members of the jury, now we turn to summations. The government will make its summation first, then the defense will follow. As I said yesterday, after the parties' summations, I will provide my final instructions. In making their summations, the government and the defense will review the evidence you've heard and seen during the course of the trial, and will suggest to you certain inferences or conclusions which they, in their opinion, believe may be properly drawn from the evidence in this case. If you find a particular attorney's analysis of the evidence to be correct and accurate, then you are at liberty to adopt such inferences and conclusions in whole or in part. On the other hand, if you find that a particular attorney's analysis of the evidence to be not correct and not accurate, then you are at liberty to disregard such inferences and conclusions in whole or in part. Either way, you are free to draw your own conclusions based on your analysis of the evidence presented. Nothing said by either attorney in their summations is evidence. In this case, it is argument. The instructions on the law that I provided to you yesterday and this morning, that I will provide following summations, are not evidence either. You have heard all the evidence in this case. You, and you alone, are the sole and exclusive judges of the facts in this case. We will now hear the summation of the government by Assistant United States Attorney Ryan Finkel.
Mr. Finkel said, thank you. Good morning.
Audio played.
Mr. Finkel said, that's the real Miles Gua.
The court said, Mr. Finkel, please get close to the microphone.
Mr. Finkel said, that's the real Miles Gua. The person that Brother Seven, the supposed political activist, never thought his followers would hear. The real Miles Gua, who he never thought anyone would hear. And especially not a jury in a criminal trial. But you heard it. You heard the proof behind all these G entities. G TV, G Club, G News, G Mall, G Fashion, the G Series. Miles Gua was the man in charge, the boss. It was Gua himself, this man, who spouted devious lies to trick his followers into giving him money. Lies he told time and time and time and time again. Lies he told so he could take other people's money. That recording that you just heard was on April 28, 2021, in the thick of this fraud conspiracy. Miles Gua, Yvette Wong, and William J., who's also known as Mr. UYU, were recorded unknowingly to them by Haitham Khalid. Now Gua, Yvette, and William didn't know that Haitham was creating a record of their discussion. A discussion about how and whether to paper the movement of $100 million of G Club member fees, fraud proceeds. How to move that money from a G Club bank account abroad to Hamilton, to William J.'s foundation, which he operated in London, in Abu Dhabi. Now Yvette, as you may recall from the recording, was concerned. She thought they at least needed to go through the G Club's board, meaning Howard and he, the paper ultimate beneficial owner of G Clubs. Miles Gua's son, best friend. Yvette pleaded, "Do you think a normal company would do this? Just send the money off like Gua wanted?" Jay said they could just use G dollars to make it look real. They discussed using H coin, Himalaya coin for compliance. Yvette wanted those things to make sure she can answer questions from banks, from regulators, from the Securities and Exchange Commission, from U.S. law enforcement, so that the scam would look legitimate. So they could hide their crimes. But Gua interjected. Gua asked whether Howard, the paper owner, authorized Alex H., the G Club's controller who worked in Manhattan, whether he was authorized to move the $100 million. Yvette Wong reasserted that that's not enough. They should go through the board. They should make it look official. But Miles Gua, boss, the principal, the man in charge, he did not want to wait. With that context, let's listen again.
Audio played.
Mr. Finkel said, Miles Gua ordered that they move the money as a so-called investment from G Club's member proceeds. Victim money, that they move it abroad to Hamilton. Miles Gua, who on paper is just a spokesperson for G Clubs, was recorded on tape. And you heard it. Government Exhibit 417. He controlled the money of G Clubs, which is to say what is obvious, what is known, what is clear. Gua controlled G Clubs. He directed how the money would move and when. And they did it. They papered it with this document on the left side of your screen that has an effective date of March 6, 2021. A backdated transfer, $35 million. And more, as the bank records show, followed from G Club's operations to Hamilton Digital Assets. G Clubs existed so that Gua could take other people's money, and that's what he used it for. Now, this trial began about 7 weeks ago to the day, and between then and now, you have learned and you have seen evidence about the real Miles Gua, the man who, from 2018 through 2023, received hundreds of millions of dollars, money Gua got and spent on himself and his family. Money Gua got because he lied, because he committed fraud, because Gua laundered those fraud proceeds and tried to cover it all up. And in the process, Miles Gua agreed and, in fact, actually built an enterprise of fraud. He engaged in a racketeering RICO conspiracy. That's what he did. That's why he's guilty. Now, the RICO conspiracy Miles Gua engaged in that you have heard about was made up of all these companies and entities and organizations. The Himalaya Farm Alliance, the Iron Blood Group, the Himalaya Exchange, Hamilton, Mountains of Spices, ACA Capital, Sriracha, Golden Spring, Lamp Capital, Crane, the New Federal State of China, the Rule of Law Foundation, and entities that bear Gua's name: G News, G TV, G Clubs, G Fashion, G Bank. As Gua himself called it, the G Series. There are other entities. I could go on. But make no mistake about it, this was Miles Gua's enterprise. What the indictment in this case has turned the G enterprise for Miles Gua. An association of entities and people within them that carried out Gua's vision to erect a fraud empire. A fraud empire that committed wire fraud and securities fraud and bank fraud and laundered money, and it targeted people. His enterprise targeted people who tried to get between Gua and his fraud proceeds. Gua used the G enterprise to buy whatever he and his family wanted. That's what it was for. That's why he did it. That's why he's guilty. So you have seen the evidence, you've heard from all the witnesses. And now you know this was a scheme, this was a con, this was a fraud. And Miles Gua, that man, was behind all of it. And though the scheme was vast and the enterprise was wide-ranging, its core, its foundation, so simple. Miles Guo lied to take other people's money. That's it. He streamed videos of himself over the internet. He lied to the people who watched them, his followers. He said, send money. Invest. He promised his followers, his supporters, you're not going to lose money. I'm rich. I'll take care of you. You're going to get stock. And he lied. Not just once, he lied for years and dozens and dozens and dozens of broadcasts of videos.
Video played.
Mr. Finkel said, I can guarantee you will never lose money. I bear legal responsibility. Dear brothers and sisters, if anyone loses money, come to me, come to me. I will be responsible. Let me repeat again. As long as you lose a penny, I will be responsible. Guo's words himself on tape, recorded. That, in a nutshell, are the lies that Guo told to take other people's money. And at its core, as I said, it's all very straightforward. Guo's fraud was based on a simple lie. Simple lies. It was grand at its scale. This closing is the government's opportunity to take you through the evidence that you've seen and heard. And to do that, I'm going to do a few things. First, very briefly, remind you of the charges that Miles Guo is facing. Then I'm going to go through what, in the government's view, cannot seriously be disputed by the parties. Third, I'm going to discuss the schemes, Miles Guo's schemes. The schemes he used to defraud people. And then fourth, I'm going to go through some of the reasons, there are others, but I'm going to go through some of the reasons that Miles Guo is guilty of every charge in the indictment. So as you know, and as you heard from Judge Torres yesterday and today, Miles Guo is charged in 12 counts. The first 4 are conspiracy counts. Charges 5 through 12 are what are called substantive counts. And Judge Torres has explained to you the difference. Guo is guilty of the conspiracy counts because he agreed with at least one other person to commit a certain crime. And he's guilty of the substantive counts because he committed a certain crime. Or he aided and abetted someone else committing that crime. And so here, Guo not only committed crimes, but he agreed to commit crimes. He conspired with Yvette Wang, William J., his son, Miles Sun Guo, Howard He, Max Krasner, Long Island David, Yongbing Zhang and others, to build a criminal enterprise, a racketeering enterprise. A group of people who were associated together for the common purpose of taking other people's money through fraud. And they engaged in a pattern of criminal activity, of wire fraud, of securities fraud, of bank fraud, of money laundering, and of unlawful monetary transactions, using fraud money to buy things. These are the conspiracy charges, as Judge Torres has explained, and Miles Guo is guilty of all of them. And these are the substantive charges, which are based on the various schemes, some of the various schemes that Miles Guo committed. The GTV private placement, the farm loan program, G-Clubs, the Himalaya exchange. Count 12 is a charge for engaging in an unlawful monetary transaction, specifically the $100 million of victim money that Miles Guo and his co-conspirators sent to Heyman Capital to invest in hedge funds. Now, with all the evidence in, step back and think about it. There's a good amount here that cannot seriously be disputed. So I want to start there. With what cannot seriously be disputed. First, it cannot seriously be disputed that Miles Guo made dozens and dozens, actually hundreds, of broadcasts and videos about various businesses and investment opportunities. You have seen many of them. Victims have told you about them. You have seen Shamal Medrano's summary chart, which is GXZ9. A 200-page chart of just excerpts of what was said. And all the videos that chart summarizes are in evidence, and you can review them. There is no serious dispute that Guo made these videos, that Guo said these things. that they were broadcast from Gua's YouTube page, from his media outlets, his own media outlets, G News, GTV, from Getter, his social media platform. Gua's statements themselves, the statements alone, GXZ9 itself, is damning evidence of Miles Gua's guilt. By the way, if I mention an exhibit or you see an exhibit marked in this closing deck that you want to take another look at later while you're in the jury room, feel free to just jot it down. You're going to have access to every exhibit and every witness testimony you wish to review, but you won't have access to the parties' closings. So if I mention something that you want to take a closer look at, feel free to make a note of it. Second, it should not be seriously disputed that these investment opportunities raised hundreds of millions of dollars. You're looking at a piece of a bank summary chart which summarizes thousands of pages of bank records. Now, I'm sure the parties dispute what this means. But you know what it means. It means the videos, the broadcasts. Miles Gua's broadcasts worked. His legion of statements mattered to people as they forked over their money to participate in his investment opportunities. Next, it cannot seriously be disputed that Miles Gua worked with others to carry out his businesses, to carry out his investment opportunities. You've heard from several witnesses that Miles Gua ordered his staff and others to carry out his vision. And key to that were two people in particular, Yvette Wong and William J. Ms. Wong was the head of operations. She ran the day-to-day of each business. William J., described as the finance guy. He kept track of Miles Gua's money and helped launder it. But there were others. There were others too involved in Gua's investment schemes. Names you've heard and individuals whose actions you have learned about. Now, these co-conspirators also worked for Gua. They carried out his vision. They helped him spend his followers' money. They helped him launder it. They helped him try to cover it up. There's Howard He. He's the paper ultimate beneficial owner of G Clubs, Miles Gua's son's best friend. There's Miles Gua himself, who you heard on the recordings that Haitham Khalid made, talking about moving fraud proceeds abroad. There's brother Long Island David, who you've heard a lot about, who was named by Miles Gua to be the head or the Secretary General or something like that, of the Himalaya Farm Alliance, who lied to people too. There's Yongbing Zhang, the criminal, emphasis on criminal, defense attorney or, immigration attorney, who asked Yuli to sign a false affidavit, who was gifted a Lamborghini by G Clubs. And then there's Max Krasner, the man who cut the checks and papered the many items that Gua purchased for himself and his family, who worked in the New York office alongside Yvette Wong and Miles Gua. That's the conspiracy. Fourth, there cannot and should not be any serious dispute that actions were taken in this conspiracy with respect to these crimes, and that wires traveled into and out of Manhattan. As you heard from Judge Torres, one of the things you'll need to consider is venue, which is whether any actions were taken in the Southern District of New York, which includes Manhattan. There should be no serious dispute about this. The offices that ran the various Gua businesses were in Manhattan. You may remember Limari Reyes described them as being on the right side of Central Park and the left side of Central Park, the east side and the west side, the townhouse on the left side of your screen, and 3 Columbus Circle on the right side of your screen. And, of course, right in the center is the Sherry Netherland Hotel, where, as you can see from this photo alone, Miles Gua made broadcasts that traveled throughout the country and throughout the world to further his enterprise. There should be no dispute about interstate commerce either. Obviously, as money is moving back and forth, that has at least a minimal effect on interstate commerce. And, in fact, It was stipulated that there were victims in the Southern District of New York, that's GX Stip 19, individuals who received money back from the SEC as a result of the private placement fraud. It also should not be in dispute that a red Lamborghini was found in the garage of Miles Gua's estate in Connecticut. Now, it should also not be disputed that the VIN number on that Lamborghini matched exactly the VIN number on a document that G Clubs had. Now, I suspect there is a dispute about what this means. Here's what it means. This Lamborghini in Miles Gua's garage is itself devastating evidence of his guilt. It shows he made statements about G Clubs. Money came in, and it was spent on a Lamborghini that ended up in his garage. And the keys were in his house. You held them. Frankly, the Lamborghini is enough itself to find Miles Gua guilty on all the conspiracy counts and counts 7 and 8. The G Club counts. Another thing that is not in dispute is that the CCP targeted Miles Gua. The government stipulated to it. My name, our names, our boss's name, are on this stipulation in the signature block. That means the government agreed the CCP posted things online about Miles Gua. They tried to extradite him. Didn't work. Parties also agree that the FBI charged the people who targeted Miles Gua. The FBI charged them with violating U.S. law. That's what the FBI does. The CCP targeting Miles Gua might be why Miles Gua has so many cell phones. I don't know. I don't care how many cell phones Miles Gua has, and neither should you. What you should care about, what was on those cell phones. And we'll talk more about that later. This is a fraud case. And so the CCP targeting. Why does it matter? Does it matter? Well, let's take a look at what Gua's targeting expert, his fox hunt expert witness, said about this very issue. The business opportunities that Miles Gua promoted have nothing to do with why you were hired here to testify today. Correct? Answer from the expert. I was hired to testify as an expert in the Chinese intelligence and police agencies. And Operation Fox Hunt, which is to say targeting for Miles Gua. Question. That has nothing to do with the business opportunities that Miles Gua promoted, correct? Answer. Correct. That's what Gua's well-paid expert believes. Paul Doran also testified that he was targeted by the CCP. But he knew. Of course, that didn't give him a license, it's what he said, to commit fraud. There's no justification defense in this trial. There's no duress defense in this trial. None. So is Miles Gua targeted by the CCP? Yes. Does that excuse what he did? No. And what does it mean for the questions that you as a jury have to consider? Very little. This is Minran Wu's testimony. Question. If it were true that Miles Gua was targeted by the CCP, does that change your view of the investment projects? No. Does it change your view of the movement? No. Why doesn't it change your view? This movement is just a scam. I don't think it's related anything to the CCP. Also, if somebody is anti-CCP, it doesn't mean this guy could scam somebody else. That's different things. You cannot use this anti-CCP to do something illegal. So that is what cannot seriously be disputed. Now we're going to turn to Miles Gua's schemes. Gua's enterprise carried out several schemes. Each scheme, by the way, is a RICO predicate act. And there are more than just these 6, but these are the 6 we're going to talk about. Each scheme was designed to take other people's money, the money of his followers. The men and women around the world who believed Miles Gua, who believed in Miles Gua. Now, those schemes were principally the Rule of Law Society and Foundation Scheme, the GTV private placement, the Farm Loan Program, G Clubs, the Himalaya Exchange, and A10. As I mentioned, there were others too, G Dollar, G Coin, G Bank, a second GTV private placement. We're going to focus on these 6. Because at their core, these 6 are really kind of all the same. Miles Guo first would tell lies in broadcasts to get his followers to send him money. Second, those lies mattered. They were important to his followers in deciding whether or not to invest, whether or not to send Miles Guo and his company's money. Third, money poured in, tens of millions, hundreds of millions, $1 billion. Fourth, the money was washed. It was laundered by William J. and others through Hamilton. You heard the recording, ACA. Or otherwise cleansed through these businesses that were designed to look legitimate. To try to trick U.S. law enforcement, to try to trick you. And fifth, after the money was cleaned, Miles Guo used the money for himself, for his family. Through it all, Guo, the boss, the principal, was in control. He was in control of the companies that bear his name and of the companies that do not. When he wanted to hide certain things, so he named a company called Medical Supply or ACA Capital even. So at its core, it's so very simple. In some ways it's kind of just one long big scheme that kept evolving and changing. When the SEC caught on, they adapted their methods. When assets were seized, Guo made another change. But it's the same foundational principle. Miles Guo lied to take other people's money. Let's go through these schemes briefly. First, there's a rule of law society and rule of law foundation scheme. In this scheme, Miles Guo said that he would donate his own money and, by so doing, encourage people to donate theirs. Money came pouring in, and he spent it on himself and to promote himself. The GTV private placement. Miles Guo said he's going to create this media company. Invest. Buy shares. Money came pouring in. He cleansed it through Soraka and invested it in a high-risk hedge fund in the name of his son that lost $30 million. Then came the Farm Loan Program, which was operated through the Himalaya Farm Alliance, which Miles Guo created, which Miles Guo names who is in charge of each farm. He offered so-called loans that he said would be used to be working capital for the farms. And in exchange, people would get stock. No one got stock. No one got interest payments. But Miles Guo and his family took the money. Then there was G Clubs, another stock-related scheme. This time you buy a membership. You get GTD stock or G Fashion stock or G Club stock, or you buy the stock and you get the membership. He did it both ways. Money poured in. It was cleaned. Miles Guo spent it on himself and his family, including putting that Lamborghini in his garage. The Himalaya Exchange, a cryptocurrency-related scheme. These cryptos are going to make you rich. You're not going to absorb any losses, he would say. They are backed by gold. They are safe. They are valuable. In truth, not only weren't they backed by gold, but after a certain point, they weren't backed by anything. They weren't on the blockchain, and the price was manipulated. And what happened to that money? A lot of it was seized by the U.S. government. But before it was, when he needed $37 million to get out of a jam with a court in New York State, he got it, like a bank account. Then there's A10, which is just A10 is pure snake oil. This was a business opportunity that emerged shortly after the U.S. government seized, as I just mentioned, hundreds of millions of dollars. And Guo promised through the A10 a stake, 5% getter. 5% in the Himalaya Exchange, you're going to get these stocks. Didn't make any sense, but money came in. Those are Guo's schemes at a high level, each of which was integral to Guo's fraud. Each of which he promoted in his broadcasts, and from each of which, he and his family benefited. Now I'm going to discuss some of the reasons that Miles Guo is guilty of every crime with which he is charged. I'm going to go through 7 reasons. There are way more than 7. We only have so much time. So I'm going to go through 7. Here's the first reason. The first reason you know that Miles Guo is guilty is he lied to his followers about these investment opportunities. Miles Guo told these lies, not the Politburo, no one else. He himself told these lies, this man in the courtroom. Now, there are a lot of lies that he told. But they mostly fit comfortably under an umbrella of 2 lies in particular. First, he guaranteed that his followers would not lose money, and he said his followers would make money. And he said these things over and over and over and over and over again. His former close associate, who testified here, Yili, was known as Milan, summed it up for you well in her testimony. She was asked, what promises, if any, did Miles Guo make about the investments? Her answer, and she watched hours upon hours of his videos. Her answer, he guaranteed all investment will be no loss. If there's a loss, he will repay us all the loss. Here's another excerpt from her testimony. Ms. Lee, was this video, the one that she had just watched, the only time Guo made this type of promise? No, many times during this 3 years. How often would he say these things in the 3 years? The promises about investment. How often would Miles Guo make these promises? Always. So those are the big umbrella lies. But there are lies that are specific to each scheme that fit underneath that umbrella. That fit underneath the guarantee and the promise of returns. So let's now start with the lies Miles Guo told about the rule of law. Rule of law launched in November of 2018. About a month after the CCP seized Miles Guo's money. We're going to come back to that. It launched in November 2018 at a big press conference with Steve Bannon. Let's take a look in part at what Steve Bannon said.
Video played.
Mr. Finkel said, now, Steve Bannon wasn't freelancing here. Karen Maestrello, Miles Guo's interpreter, a few weeks ago. But you may recall, she told you that she participated in meetings where Guo and Bannon discussed this very fact that Miles Guo was going to donate his own money to the Rule of Law Foundation and Society. And it's not some accident, by the way, that Steve Bannon was involved at all. Miles Guo used Steve Bannon. He was hired for $1 million so that Guo could use Bannon's notoriety and his fame to promote himself. Rule of law is where all this sort of started. Guo paid Bannon $1 million. That's what you're looking at now. His contract through Soraka. Soraka Media Group, which really, as you will see as we continue today, is Miles Guo's slush fund. Now, there's no way Miles Guo paid this guy $1 million and let Bannon freelance about what to say at the media launch. But that's okay anyway, because Miles Guo himself made the same false promise. This is Miles Guo's words. Government Exhibit 6-191 translated in 192T. Guo Wengui's $100 million will be donated to the Rule of Law Fund. I bear legal responsibility for what I said today. In other words, for every US dollar donated by comrades in arms, $2 come from Wengui. After donating the $100 million US, Wengui is coordinating a donation of $1 billion to the Rule of Law Fund. He tells his followers he bears legal responsibility. He does. He knows he is making a promise that matters to them. But it was a lie. You may remember this document. It's GXWA 30. It was found in Yvette Wang's apartment on March 15, 2023. Yvette, of course, was Miles Guo's right hand, really his right arm, who carried out his orders and kept all the businesses and entities and people running. And this is a summary in Yvette Wang's records of all donations the Rule of Law Foundation and Society. And what does it say? The total, both entities, $36 million. Not even close to $100 million. And that document, by the way, is consistent with what Karen Maestrello, who was the president and treasurer of Rule of Law Society, told you. Did Mr. Guo ultimately make $100 million donation? No. So that claim for Miles Guo that he donate $100 million and $1 billion was a lie was nonsense. But there's more that Miles Guo lied about. Guo and Bannon in that press conference. They pitched the rule of law as a way to help people who were oppressed by the CCP as a charity. And Guo would talk about that mission, how to further it, through the rule of law time and time again. What did the Rule of Law Society and Rule of Law Foundation actually do? You said the purpose was to help people in China, Ms. Maestrello was asked. What, if anything, did Rule of Law do to help people in China? While I was there, nothing. It's actually worse than that. Because boss, Miles Guo, did less than nothing. He took Rule of Law Foundation and Society money, donor money, victim money, and he spent it on himself and his family. Guo used Rule of Law money to send a shipment of N95 masks in March of 2020. On the onslaught of the COVID pandemic, when no one could get an N95 mask anywhere, not even in hospitals. Not in Home Depot, there were none. And Guo used donor money to send a shipment of those masks to his estate in Connecticut. But there's more. Guo did use some donor money to send some masks to the NYPD. Karen Maestrello testified about that too. You may recall what happened next. Guo demanded personal credit for doing so. And Maestrello was asked to write a letter, saying that those masks were a gift from Miles Kwok. Even though that wasn't true, because they were a gift from donors. Maestrello refused. Because it was not a direct gift from him, she said. It was donor money. Rule of law money. What did Yvette say to her? What did Yvette Wong say to Maestrello as Yvette was carrying out Miles Guo's orders? She told me, Maestrello said, that I was being paid to execute orders and not to think. You didn't know it at the time. At the time that Maestrello testified about that. But that was a prelude of things to come. That's, in part, how the RICO conspiracy worked, how Guo's enterprise worked. Recruit people who don't ask questions. Recruit people who follow orders, who understand the company line and carry it out. People like Jesse Brown, president of the Himalaya Exchange. People like Limari Reyes, the CEO of G Clubs. We'll come back to that later. So one of the reasons that Miles Guo is guilty is he lied in the rule of law scheme. He lied about donating his own money. He lied about how donor money would be used. He lied about how the money would be spent, because he spent it on himself and his family. And he used it to promote himself. Now let's talk about the lies Miles Guo told to take people's money in the GTV private placement scheme. Reeling from the success of rule of law, this is when the scheme and the enterprise became turbocharged. On April 20, 2020, Miles Guo announced the private placement. He told his followers, "We are friends." And he explained that GTV would be a social media platform with functions such as one-to-one chat and group voice messages like WeChat in China. He explained he wanted to create a media company that would break through the Chinese firewall and bring democracy and freedom to the Chinese people. And he told his followers to read the private placement memorandum. This document says at the top, "Everything is just the beginning." And inside that document it emphasized that the purpose of this private placement, the purpose of this company, is to create a platform independent of the Chinese government censorship. To create a unique and the only news-focused social media platform revealing the truth about China. To be a bridge between China and the Western world for open communication, business transactions, and trading. and was specific about how the money raised in the private placement would be used. It would be used, it says, on the right side of your screen, to expand and strengthen the GTV business. Nowhere does it say in here that the money could be used for a high-risk hedge fund bet. That wasn't included on purpose. But beyond the private placement and beyond the news conference, Gua also made representations to individual investors, the old chairs, as they were known. Wei-Chin was one. She testified about it. She told you how she texted her and her husband texted, exchanged messages, with Miles Gua. And she told you her understanding of what Miles Gua had told her, that she was promised only returns, huge returns. Zero risk. Question: that's what Miles Gua said? That's exactly right. Then on June 2nd, 2020, the private placement closed. Gua explains in that video, in that broadcast, that this is that he had a separate conversation with each investor. That this is a serious and solemn commitment and responsibility of Gua to you to be responsible for this investment forever. Forever. It's a legally valid commitment, he says, an attitude. It's June 2nd, 2020. Do you know what he doesn't say in that video? He doesn't mention, because he doesn't want the victims, his fellow fighters, his friends, as he called them, to know the truth. That at that point, he was committed to spending $100 million of their money on a high-risk hedge fund bet with Heyman Capital. The GTV private placement closed on June 2nd. The next day, Gua moves $100 million of investor money to another bank account. From the Chase 5601 account to the Chase 2038 account. And from there, $100 million flows into Heyman Hong Kong Opportunities Fund, the hedge fund in Dallas, Texas, run by Kyle Bass. And you heard from Steele Schottenheimer, the managing director of investor relations at Heyman. She explained to you that this Hong Kong Opportunities Fund has nothing to do with the media company at all. Nothing. It's a bet against the Hong Kong dollar. She explained it as a bet when the band breaks on the weak side. The band breaks on the weak side, it could pay off. This was not a bet in the S&P 500, not that that would make it okay, it wouldn't. This was not a bet or an investment in Coca-Cola, again, not that that would make it okay, it wouldn't. This was a hedge, a high-risk investment for qualified investors. It was a high-risk gamble on the Hong Kong dollar price. Just to be clear, that 5,601 account is investor money. It doesn't take a lot to figure that out. Just looking at the bank record shows the wire transactions into that account list in the wire's GTV investment. Attention to Mr. Miles Gua, for GTV stock, $291.5 million, over 2,400 deposits. Floated into that account in 1 month, in May of 2020, made references to GTV, stock, investment, private placement, capital, and so on. This is Steele Schottenheimer's testimony. She explains what you know. That the Hong Kong Opportunities Fund is a very high-risk, potential high-return strategy. She explained how it's designed to hedge people's risks, qualified investors' risks. And that investment, by the way, is something that Miles Gua had contemplated for a long time. You saw this video. This is W1007V1. It's an interview that Miles Gua did in English with Kyle Bass, where they talked about the Hong Kong dollar peg. When it could break, when it could not. Moreover, during the private placement, while victim money was coming in. As you just saw, Gua's moneyman, William J. requested and received the deal materials from Heyman Capital. This is May 23, 2020. This is when we know by at least this time that Miles Gua had decided to make the investment. And remember, after that, June 2nd, he talks about his solemn commitment. 3 days later, this is a text from Kyle Bass to Steele Schottenheimer. It was made clear to Schottenheimer that Miles and William were investing through two entities, Soraka Media Group and Hamilton Investment Management. Soraka Media Group being a Miles GWA entity, the entity he was using to funnel fraud proceeds to Heyman Capital. So GTD private placement closes. The money goes into the Heyman Hong Kong Opportunities Fund, but then they hit a snag. The Securities and Exchange Commission, the SEC, an American securities regulator, contacted Heyman. That was on July 13, 2020. Steele Schottenheimer told you about that. She said that Heyman received a call from their lawyer that they had received a letter from the SEC requesting documentation regarding Soraka's investment in the Heyman Hong Kong Opportunities Fund. So in response, Heyman's lawyers sent a letter to Soraka, GWA's family entity. And they asked some questions. What was the source of capital used by Soraka Media Group to invest in the fund? Was any of the money raised in GTD's primary offering of shares used to fund Soraka's investment in the fund? If the proceeds were derived from a securities offering, did the offering documents disclose the use of proceeds to include an investment in the fund or in any similar private fund vehicle? If yes, please provide a copy of the disclosure document. What, if any, response did Heyman receive after dispatching that letter? No formal response to that letter. No response. Soraka did not send the private placement memorandum and point to the document that says, "This is how we could use the proceeds." They did not send the private placement memorandum and point to the part in the document that says, "Management has broad discretion in how to use the net proceeds of the sale of common stock." They didn't send the private placement memorandum at all. Why? Why did Soraka not send the private placement memorandum to Heyman? Because the private placement memorandum does not allow them to use the money raised for a media company to invest in a high-risk hedge fund in the Hong Kong dollar. If they thought it did, if they truly believe that the private placement memorandum means we can do whatever we want with the money, they would have told Heyman that.
Continued on next page.
Mr. Finkel said, they didn't cause Miles GWA knew. Yvette Wong knew. William J. knew, and you know. The money was sent for the GTD company, not for high-risk debt in the name of Miles GWA's son. By the way, this is proof that Soraka got the letter that Heyman's lawyer sent. Because this document, the letter we just looked at, this is from the SEC. If you recall, there was a witness who testified from the SEC that the SEC sent a subpoena to Soraka. And in response to that subpoena to Soraka, Soraka produced the same letter from Heyman's lawyers. So it's clear that Soraka got the letter and never responded to it. Then in August of 2022, Kyle Bass himself sent an email to William J. And in part that email said, in order to allow Soraka to remain invested in the fund, the Hong Kong Opportunities Fund, the high-risk hedge fund bet, Heyman needs to receive a representation from you and from Soraka's lawyers regarding the specific source of the money. The $100 million, beyond what was initially provided in the subscription documents. And the representation must include that this money is not tainted in any way, including that it does not represent assets from the GTD offering, but that it's a bona fide investment made by Soraka and Miles GWA. Did Kyle Bass get a response? No. Did Soraka ever provide a representation from itself or from its lawyers regarding the specific source of money? No. Was there any representation made that the money was not from assets from a GTD offering according to Steele Schottenheimer? No. Was there any representation made by Soraka or its counsel that the $100 million investment in the Hong Kong Opportunities Fund Prodigious Series was a bona fide investment made by Soraka Miles Kwok? No. This is evidence of intent, of Miles Gua's intent. By the way, what happened to that $100 million? That $100 million of investor money, of follower money, of victim money, money from the fellow fighters? Well, $70 million of it was sent to the SEC. But $29.6 million, $29 million was lost in the investment. Gone as part of that investment. Soraka made a $100 million investment. What happened to that $100 million? Steele Schottenheimer told you. 70 of it was segregated and moved to a feeder fund. How much was lost? $29.6 million. Did Miles Gua live up to his promise that he made on video that you just saw? His promise to protect his followers' investment in GTV? No, he did not. How do we know that? Wasn't already obvious? There's a stipulation in this case that Soraka, GTV and VOG made a settlement with the SEC, and as part of that settlement, they agreed to pay back the money that was part of the GTV private placement. And as of the date of this stipulation, which was June 21st of this year, Soraka and GTV owe almost $31.5 million more. So Miles Gua has not made good on his promise. And why? Because he was lying when he made that promise. And why did he lie? To try and to in fact take his victims' money. Just to be clear, his promise extended to the voice of Gua investors too. You may recall the GTV private placement had the old chairs. The people who invested directly with Soraka like Wei Chen. And then there was the VOG investment. The voice of Gua investment, which was the pooling when people who couldn't afford $100,000 pooled their money through voice of Gua, which was in effect a farm. Miles Gua promised to guarantee their money too. I will be responsible. If there is one of your pennies that's missing, a penny, Igua Wigui will be responsible. So these are the GTV lies. Gua lied about what GTV investment money was going to be used for. He lied about guaranteeing any loss. And in fact, he just spent investor money on himself and his family. Now let's turn to the farm loan program. Recall that the farm loan program began shortly after the SEC started asking questions about Soraka and its investment in Heyman. Rather than sell securities explicitly, that is, sell stocks of GTV explicitly, Gua said he'd sell loans. Loans that brought with them the promise, his promise, of stock ownership or interest payments. And as you will see, and as you well know, and as Gua well knew, those promises were lies.
Media played.
Mr. Finkel said, Miles Gua's words. By the way, those sunglasses he's wearing in that video, those are the same sunglasses Yuli brought to this courtroom that Miles Gua had sent her, as a sign of his appreciation for what she had done, for what she now knows she told you was a giant scam. Victim testimony that you heard is consistent with that video. This is Minran Wu. What was the farm loan program? We members lend money to the farm to get GTD stock. Why did you understand that lending money to the farm would get you GTD stock? He said so. Who are you talking about? Miles Gua. Here's some more from Minran Wu. What, if anything, did Miles Gua say about why you had to use loans instead of just investing in GTV? He said for the GTV private placement already finished, already ended. So he created another chance for us to invest in this GTD stock. He called this step to equity. Here's some more statements that Miles Gua made that were not true about the farm loan program. I'll give you the money. I'll be responsible for everything, okay? People should never, ever worry about this. He goes on. This is the United States of America. You are legally responsible for what you say in the video. I am legally responsible. His words on a boat. Here's some more. Just with the investment of GTD, we managed to raise more than $400 million so far. We haven't spent a penny of that. That was on February 28, 2021, after ye had sent the money already to Haman. The farm will give you clear notice that all the money you lent them is inconvertible bonds. I call you to specify, and you will go to the account I specify. If any of you lose money, I will take full responsibility. In my live streaming today, I say anyone, as long as you follow Reviewing News Alliance. As long as your money was deceived and stolen, what I said was based on the original rule. For those involved in what GTD Phoenix Farms or farms like this, I am fully responsible. Miles was words. So, victims got contracts. This is Minran's contract. And the contracts say that the loans proceed under this agreement are for the general working capital purposes of the farm. The loan agreements do not say what was true, which is that Miles was going to use the money for his personal expenses, for his family. It also does not say that they will get stock by the way. And he did that because this was designed to obscure the fact from the SEC that he was promising his followers stock. Ms. Wu explained that to you. The use of proceeds does not mention GTD stock, right? Yes. What, if anything? Were you told about why that was? They said they couldn't write clearly about that in this contract just because of the CCP, because CCP always eyeing this group. They couldn't do that. And who told you that? Miles was said this, and Brother Long Island said this. Xia Qidong said this. CCP being a replacement for the SEC. That's what this was about, hiding it from the SEC. Ms. Lee, were the farm program contracts real loans? No. They were for GTD shares. Where did that money go? Where was it sent? The farm loan money? Yeli told you. It was sent to ACA Capital's bank account in Abu Dhabi. William J.'s bank account. And that money from William J.'s bank account in Abu Dhabi from the farms to ACA Capital laundered, and then sent on to Lamp Capital. What happened with it in Lamp Capita? It was used for Miles Gua's family, for his son Chang Gua, for his daughter Mei Gua, for car-related expenses, for airplane expenses. That's not working capital for the farms. They never got stock either. No surprise there. Did you ever receive stock for your loan? No. Did you ever receive interest payments for your loan? No. What, if anything, Ms. Wu? Did Miles Gua say in his broadcast about using the money from the farm loan program investor money for himself? What did he say? He said nobody can touch our money. Even a penny safe, all safe. All safe. Did they receive interest payments? This is Ye Li's testimony. No. To your knowledge, did farm members ever receive interest payments? No. Did you receive stock, Ms. Li? No. To your knowledge, did farm members ever receive stock? No. Well, there was one instance actually. Ye Li told you about this, where interest payments were made, just one. And that is to Long Island David's farm. The New York farm, the Mountain of Spices farm. And why were those interest payments made? To trick the SEC. Question: what's your understanding of why Mountain of Spices receive interest payments? Answer: because that time SEC start investigation Mountain Spice Farm, because they want to show the SEC. This is a real loan, not for GTD shares. So what were Miles Gua's lies about the farm loan program? He lied to his followers that they would get stock for the interest payments. He lied that he would guarantee their investment. He lied about how the loan money, victim money, was going to be used. And Gua spent his followers' money, his victim money, on himself and his family. Let's turn to G Club. Gua lied about G Clubs too. In fact, Let's watch another video of Miles committing a crime.
Media played.
Mr. Finkel said, and that video is a crime because Miles is lying to try to get other people's money. And he broadcast those lies over wires. This is a video. Like so many of the other videos you have seen throughout this trial of Miles committing wire fraud. And because it's about stock, it's securities fraud too. Let's read some more statements of what Miles said about G Club. It is not a membership club, Miles says. G Club is for you to get the original stocks. The comrades who have not invested in GTD original stocks this time to be given a channel so you can get legal G Club. G Fashion stocks. That's it. Simple. So then on October 13th, 2022, GWA does the official launch of G Clubs. And in this launch, he says he's being economically me too. His words. He says, today is the launch of G Club and G Fashion and some statements that have to be made, he says, before the launch. He explains that there's a Me Too in the economic field of the U.S., not the CCP by the way, the U.S. And you can accidentally become economically Me Too'd. That's how GWA described it. What do you mean by economically Me Too'd? RGTV, take a look at RGTV and you will see. He continues, because he's being economically Me Too'd, I have to say that you will not receive GTD stock. You will not receive loans to purchase membership. This is serious business. There will not be stock. There will not be loans. No. 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 But then, he says the quiet part out loud in the same video. To put it bluntly, this is all nonsense. I'll be straightforward with you. This is what we need to have to legally avoid Me Too. There is no other way. We'd have to do that. And he says what is obvious and plain, what is clear. I don't think you'd buy a GTV membership for something like free music. If you were, why would you buy it? My suggestion would be don't buy it, but the procedures laws, measures that prevent me to have to be there to prevent economic Me Too, all of which are published on the websites. So he goes out there, he says no stock, no loans, just membership. And then he says it's all nonsense, which is to say GWA knows. He knew. He knew it was wrong. He knew it wasn't lawful to say that members in G Club would get stock. He also knows because he told his followers that. You saw him say that G Clubs is not about the benefits. The 3 hotels you get a discount in Puerto Rico. The hour or hour and a half at FAO Schwartz. The one-night dinner discount at a restaurant in London. The coffee mug and cookies for $50,000, for $10,000. Those are a farce. Those are designed to make G Club look legitimate, while Miles goes online in his broadcast and tells people, send the money, get stock. You know how else you know that Miles knew when he was saying these things that it was wrong first of all? Your common sense tells you he knew. But another way you know is in February of 2021. He received the Do Not Say Words list. Limari Reyes told you about this document. This document was found by the FBI in Miles' Greenwich estate. And this was a list of words that the lawyers at G Club told Miles he cannot say, words like shares, words like securities, words like loans, words like growth, words like GTV, words like the SEC, DOJ, prosecutors, G-coin, G-dollar, H-coin, H-dollar. They told him not to talk about his schemes. He knew better. Of course he knew better. He did it anyway. February 2021, this is June 2021. All G Club card holders are entitled to 1 to 10 of the new GTD stock for the amount of the card. Please cherish each and every share of your GTD. You have to remember this, I'm just begging you. Take your membership, take your shares. Don't lose a single share. Oh my! This is big money. Think about the value of GTV. He said that after the Me Too video, after the Do Not Say list. Because of course he knew. Of course he knew. July 5th, 2021, G Club is definitely we have a solution. Which is legally approved. We have all the investors in G Clubs, all investors now who are currently set at $50,000. When paying $50,000 for the membership card, you will have 10,000 shares of G Fashion in the future. It's like giving them 10,000 shares for free. Here's another video, July 30th, 2021. He references Brother Long Island. Meaning he's referencing the farms, because the farms were integral to all of this. The farms help promote the G enterprise, the schemes, the fraud. Brother Long Island and Kai told me that some of the fellow fighters, the victims, his followers asked, "Will I still get a free stock offer when I buy a G Club membership?" 100%. Anyone can choose whether to use your money to buy G Club before September 17th, G Club and the stock shares. You'll get both. The video he made in a Rolls Royce to try to show his followers how rich he is. How his guarantees mean something, how he could be trusted. That's part of the con. That's part of the fraud. That's part of what Miles Wood decided to do. That's why, by the way, G Club offered multiple memberships. This is an email from Yvette Wong, Miles Wood's Chief of Staff Operations. She sent it to Limari Reyes and Jessica Mastro Giovanni at G Club from her Office Work 2020 at Proton Mail account to set up multiple memberships. Now, you also learned what multiple members get. You get one membership. You learned about this. This is the discount at the hotels in Puerto Rico, the dinner in London. There was a couple of weeks of a hotel in New Zealand. What do multiple members get that single members don't? They get additional entries to the G Talk sweepstakes. That's it. Did you know why that's the only difference? Because multiple memberships were not about providing additional benefits, it was a way to conceal we're buying. Or thought they were trying to buy additional stock. And what do we know about that sweepstakes and G Talks? It was fixed. Miles was immigration attorney, who carried out his criminal acts got a Lamborghini. That's not a coincidence in the G Talk sweepstakes. Miles Gua also explained to get stocks through G Club you have to send money to Crane, which collected the fraud proceeds, Hatham Khalid's entity that Yvette asked him to set up. Here's another pitch from Miles Gua, August 2021. Do you think Brother 7 is fooling you? Think about that for a moment. Do you think Brother 7 is fooling you? For fellow fighters like them. They're not just fellow fighters anymore. In my heart, he says. In my heart, they are the highest member of our G Club. That's why if you have bought the G Club membership card, you would have stocks now. Why would you lose money? What risks are you taking? Is there such a good opportunity in the world? Will there be such a good opportunity again? Will you have such a good opportunity again? And this too is promise of stock, just like so many of his other promises. Lies. Limari Reyes, the CEO of G Clubs. Question, Ms. Reyes, did G Clubs provide its members stock in G Clubs? No, it did not. Did G Clubs provide its members stock in G Fashion? No. Did G Clubs provide its members stock in any company? No. Was G Clubs an investment club? No. But his followers believed him. Mr. Joe, did you receive any stock shares in exchange for your G Clubs membership payment? No. Jenny Lee, did you receive any benefits for G Clubs? Nothing. Wei Chen, she thought she was buying shares and getting a G Clubs membership for free. Did you ever get additional GTV shares for the 110,000 you sent to ACHK and the approximately 100,000 you sent to Crane? No, I don't think so. Miran Wu, why would you think you would get GTD stock by sending money to G clubs? Miles Guo said. Where did Miles Guo say that? In his video, maybe several videos. Did you get GTD shares? No. What benefits, if any, did you get from your G Club's membership? I didn't get anything. So GTD2 was a scam. You know Miles was guilty because he lied about G Clubs. He lied about getting GTD stock. He lied about getting G Fashion stock. He lied about getting G Club stock. And he lied about the benefits. The benefits were for show so the fraud money could roll in, and so they could have some claimed excuse. Now let's turn to Miles Guo's lies about the Himalaya exchange and Himalaya coin and Himalaya dollar. And I should note that the Himalaya exchange was sort of part of a longer con that began as G dollars and G coins, and evolved into this fake cryptocurrency. Now Miles Guo's statements about H coin, H dollar, and the Himalaya exchange were varied and plentiful. There was the gold lie. There was the cryptocurrency lie. There was a lie that they were tradable on a blockchain. There was a lie that the money was guaranteed. There was a lie about price. There was a lot of lies about the Himalaya exchange. We're going to look at some of them. June 23, 2021. I want to help my fellow fighters make money. There's H dollars backing H coins, and H dollars is backed by Himalaya Reserve as well as gold. October 20th, 2021, Miles Guo says. He designed it. Brother 7 designed it at the time. It has the first one. It has the attribute of currency. Why? It has 20% gold. Awesome. No matter how much it raises, 20% will turn into gold. How to exchange it? It is the issuer of H coin. If the H coin is worthless, he can sell all 20% of the gold, exchange it to you, and become your money, or take all of the value of 20% gold and ask everyone to unify it and make it yours. He calls it a generation of cryptocurrency. Tell me who does business and dare say that you will not lose money. I can. It's all on Brother 7, Miles Guo. It's all on Brother 7 if we lose money. April 27, 2021. Let's see the sensational effect of H coin when it is listed. It is the only Chinese cryptocurrency that makes Westerners believe that is a cryptocurrency without communist and absolutely safe and law-abiding currency. May 5, 2021. He calls it a cryptocurrency several times. He goes on to say, I will be responsible if you lose it. I have H coin. US dollar gold. It is impossible to be used as a tool for money laundering crime. The pricing power of H coin is not in anyone's hands. He's talking about the price. He's saying it's not centrally controlled, and he calls it a cryptocurrency again. And William J. was broadcast on G News through the G Translators Farm talking about what a cryptocurrency actually is. Let's hear what Miles Guo's finance man has to say.
Media played.
Mr. Finkel said, so William J. defines cryptocurrency as it actually is defined. It's a distributed ledger. A public ledger called a blockchain. Miles Guo talks about it too. Any actions performed in the blockchain will be known to the whole world, meaning public. Cryptocurrency is based on blockchain have an important function, absolute fairness. Talks again about how he designed it, and no matter how much it raises, 20% will turn into gold. And he makes a video H coin to the moon. You've seen it a few times, which literally has gold in the video. And the Lamborghini that was found in Miles Guo's garage. Another comment about how it's on the blockchain. Now, was H coin, was H dollar actually traded on the blockchain? No. Was it backed by gold? No. This is Jesse Brown, the CEO of the Himalaya Exchange. Was it true, Mr. Brown? that 20% of the value of H coin was anchored to gold? No, it wasn't. How much of the value of H coin was anchored to gold? None to my knowledge. How much of the Himalaya dollar reserve was in gold? 0. This is GWA's expert cryptocurrency witness, Ms. Sklar. Ms. Sklar, in all of the documents you reviewed from the exchange, all the documents reviewed from third-party contractors, and the time you spent on Etherscan, you didn't see any evidence that H coin was backed by gold, did you? That is backed by gold. No. I didn't see anything. This is Sam Roberts' testimony. You may recall he worked at BitGo cryptocurrency services provider. They ultimately closed the account with the Himalaya exchange because of the number of red flags that the Himalaya exchange had. He did his own review. Did he find gold? No. During this account review, Mr. Roberts, what, if anything, did you learn about whether Himalaya dollar or Himalaya coin was backed by gold? Do you not recall making a finding about gold backing either of these cryptocurrencies? In fact, not only was there no gold, but after September and October of 2022, when the U.S. government seized money from G Clubs and G Fashion and the Himalaya exchange, there wasn't even backed by money. This is Bo Collins' testimony. He talks about when the U.S. government seized money that was going to be used to by his bank, which came from Himalaya exchange, by the way. This is an email that was sent actually from Ms. Murray to G Club attorneys attaching the seizure warrant, which made clear that money from a mercantile held by the name of Himalaya International Clearing, Hamilton Capital, Himalaya International Reserves, Himalaya International Financial Group, the Himalaya exchange entities was seized, but they kept using this document. The Armanino document that said the Himalaya dollar was backed by $401 million in cash. Priya Patel sent it. You remember her? She's the one who pretended that she never heard of GTV. She was the lawyer for William J. and the Himalaya exchange. It's important to keep in mind that's another example of how Miles GWA worked with other people to keep this fraud scheme going. Mr. Roberts from BitGo talked about that document. Mr. Roberts, why did seeing in this document that the exchange gave you that the number of HDO tokens on the blockchain was 0 make you question whether to accord it with your understanding of a stable coin? He had questions about it. I understood the total amount of Himalaya dollar in circulation to be in the range of 1 to 1.5 billion. Seeing this number 0 made me question whether the Himalaya dollar on the blockchain had any value at all. But despite the seizure, September and October of 2022, Miles GWA kept promoting the exchange, H coin and H dollar, talking about how it could redeem, how it could issue, and how it was extremely strict supervision. Even though it had no money behind it, he was trying to get more money to come in. Here's one of his Getter posts. His social media platform talks about how most cryptocurrencies will disappear, but HCN will continue. It can't be tainted with. It can't be stolen from. It's safe, even though there was no money backing it. Mr. Brown, in your 2.5 years with the Himalaya exchange, when, if ever, could customers buy H coin on a blockchain? Never. When, if ever, could customers buy H dollar on a blockchain? Never. That's part of this lie too. Himalaya coin and Himalaya dollar weren't on a blockchain. They weren't cryptocurrencies at all. They're on a database. Jesse Brown told you about that database, and that it was centrally controlled. Despite what GWA promised, controlled by the exchange and its technology team. And by the way, what Jesse Brown testified to, what he saw as an insider at the Himalaya exchange was consistent with what Sam Roberts saw in his review. He understood that the database meant transactions were occurring on a private ledger not available for public viewing. So it was a closed-loop system, not a public blockchain, like William J.E. described, like Miles Guo described. What they were instead were credits. That's what Maggie Sklar talked about, notations on internal databases. They're not on the blockchain, Ms. Sklar was asked. In my understanding, the credit system was not on the blockchain. Guo's own expert, it's not on the blockchain. And in the fine print buried within this 40-page document, it says that credits can only be used on the Himalaya exchange. And they represent a right to participate in trading. They do not carry any right to require their exchange for fiat currency or crypto assets. A member can make a request to the exchange to exchange credits on their account and receive a transfer of corresponding crypto assets to their external wallet address. Miles Guo never said anything about that. He left that out. And even the price was a lie. They manipulated the price of H coin. Jesse Brown. What was your understanding why stakeholders at the exchange didn't want the coins or the dollar to be listed on another exchange? For fear the price would drop, and they using Hummingbot, a software to make sure that the price wouldn't drop. They were manipulating the price. And again, Jesse Brown's testimony as an insider is consistent with what Sam Roberts saw in his review. He recalled finding that it appeared that H coin had a very large apparent market capitalization based on the number of H coin he understood to be in circulation. In other words, the price didn't make sense. That's the Himalaya exchange lies. Guo lied about it being backed by gold. He lied about it being backed by cash. He lied that he was responsible for the loss. He didn't pay it back after the government seized the money. He lied about them being cryptocurrencies. He lied that HCN and HDO were essentially controlled. They were not. He even lied about the price. Then there's Guo's lies about A10. This scheme, which is utter nonsense, comes in February of 2023, after the government seized the Himalaya exchange money. It's about a month before Miles Guo was arrested. He creates this snazzy graphic. And he makes a broadcast offering shares in both Git, the social media platform, and the Himalaya exchange.
Media played.
Mr. Finkel said, different spin on the same theme, lies about stocks, lies about coins. Lies about all these things you get if you send him money for A10. And he connects it to G Club for some reason, saying, if you own G Club without a cent, if I say that, I am not stupid. I am not a fool, and I've invested $1 million. I can get $1 million from G Club, $1 million membership. And then you hold equity owner in both companies without any risk. Then he goes on to explain that it originally was A15, but then he turned it to A10. And that's because A10 didn't involve G Club, because the G Club stock wasn't profitable at present. Which, if that were true or not true, it certainly suggests that Miles Guo knew that the G Club stock he promised to his followers that he said could never lose money. He wasn't paying them back for it. Yuli explained her understanding of A10, and what it was really for is now clear. Ms. Lee, at the time of A10, where would you send money? Send US dollars to buy a G Club card to Abu Dhabi. Why would you send it to Abu Dhabi? Because new G Club company established in Abu Dhabi. Around when was this new G Club company established in Abu Dhabi? Around the end of 2022. And what happened in the end of 2022? The US government seized Miles Guo's fraud proceeds. So he tried to move them offshore. That's what A10 was, collecting more money to go offshore. Weichen, I think, described it well. When he promoted A10, I'm confused, she said when she testified. Why? Because why is another investment? It feels to me that he just keep asking us to give money to invest. Just keep draining out our pocket, is always giving investment, but where is the return? Why keep giving money out? When is the money coming in as a return? Did Ms. Chen invest in the A10? No. Those are lies about A10. Gua lied about getting shares in Gitter. He lied about shares in the Himalaya exchange. He lied about these G Club benefits. A different spin on the same theme. So those are the lies Miles Gua told about his various schemes. The rule of law, GTV, farm loan program, G Clubs, the Himalaya exchange, and A10. These are all part of the same conspiracy. And Miles Gua kept going back to the same well, to the same people, his followers, that he knew would believe him. That there was some promise of stock, of ownership that he never meant to provide. And all of those lies that I just went through. They all fit under the umbrella of promising followers would not lose money, of promising followers they'd make money. Make money by owning stock, that Gua repeated over and over and over and over again. Our fellow fighters have to be rich. Let's see how Gua does business for you and makes money for you. I want them, the followers, to be rich. I want them to never lower their heads for money. You will make a profit. Who will you share? Who will you share the money with? And he guaranteed them. He guaranteed they wouldn't lose.
Media played.
Mr. Finkel said, that personal guarantee is pretty egregious given that Gua filed for bankruptcy on March 15, 2022. In his bankruptcy filing which he signed, he said he estimated his assets to be worth $50,000 to $100,000, and that he owed between $100 million and $500 million. In other words, he didn't have any money. But did that stop him from promising he would guarantee his investors, his followers, his victims money? Of course not. February 15, 2022 bankruptcy, he still made guarantees. July 15, 2022, this is from the video you just watched. If you lose a penny, I will take responsibility for it. He knew he was bankrupt, or so he claimed. That's the first reason that Gua is guilty, because he lied to his followers about investment opportunities. I know, Your Honor, that you wanted to take a break around now. This would be a good time if it's okay with the court to do that.
The court said, members of the jury will take a 10-minute break at this time. Remember that I have not yet given the case to you, so you're not allowed to discuss the case amongst yourselves. Don't permit others to discuss it in your presence. Don't read, watch, or listen to anything concerning any topic involved in this case.
The law clerk said, jury exiting.
Jury not present.
The court said, we'll come back in 10 minutes.
Recess.